How can minority family shareholders protect their rights from oppression? Imagine being part of a family business where your voice feels unheard or your investments are at risk. Protecting minority family shareholders is essential to keep things fair and balanced. First, having clear and up-to-date governing documents is key. These include articles of incorporation and shareholder agreements that spell out voting rights, decision-making rules, and dividend policies. They should specify how major decisions are made and set limits on issuing new shares to prevent dilution. Formalizing these rules helps prevent the majority from taking control unfairly. Next, majority shareholders have a legal duty called fiduciary duty. This means they must act honestly and fairly toward minority shareholders. If they exclude minorities from important decisions, withhold dividends, or unfairly dilute shares, these actions can be challenged legally. Courts look at whether the majority's conduct breaches this duty and harms minority shareholders' reasonable expectations. Courts also consider what promises or practices the minority shareholders relied on when investing. For example, if the family business traditionally paid equal salaries or required mutual consent for decisions, these informal rules create expectations that protect minority rights. Sudden changes that ignore these expectations can be challenged in court. Access to company records is another important protection. Minority shareholders have the right to inspect financial statements, meeting minutes, and other documents. Keeping detailed records helps them spot unfair treatment and supports legal claims if oppression occurs. Regularly reviewing these documents keeps minority shareholders informed and empowered. Preemptive rights are also helpful. These rights allow minorities to buy a proportional share of any new stock issued, preventing their ownership from being diluted. Stock transfer restrictions can keep shares within the family or a specific group, reducing outside influence that could threaten minority interests. The legal protections available depend on where the business is incorporated. Some jurisdictions have stronger laws protecting minority shareholders. Choosing the right legal jurisdiction can make a big difference in safeguarding rights. Finally, including dispute resolution methods in shareholder agreements provides a clear way to settle conflicts. Options like mediation or buyout clauses help resolve disagreements without costly court battles. In family businesses, these legal tools are especially important because family ties and informal agreements often complicate governance. Formal rules and legal safeguards help maintain harmony and ensure everyone's rights are respected. It's wise for minority shareholders to seek legal advice tailored to their specific situation to make sure their rights are well protected.